If we can now take you inside the court where after lunch proceedings are about to get underway once more.
102 subclause 2, it is my submission that there is an obligation on the Speaker to interpret the rules, which is Rule 102 to 104, as well as Rule 129, in a manner to give effect to the dual representation of members of Parliament that they serve in A, the people that they represent, and the political parties, B, that they also represent. Now, who's the people? The MPs represent all the people of South Africa. That includes voters of a particular party, and not just the voters of that party that they represent. They represent non-voters, card-carrying members. So those people who do not have a particular party that represent them in Parliament, even they are represented by members of Parliament. And it is my submission that all citizens must equally benefit from being represented in the National Assembly. And this cannot be the case when it comes to an open vote for a motion of no confidence, because all of us would know that there are members in society that have voted for a particular party that did not make the cut to be in Parliament. But it is also my submission that there's definitely an authority on the Speaker to interpret the rules to benefit the House, and she definitely does have a discretionary role. The first provision is Section 57, which provides, in particular, not the clauses that was referred to earlier, but Section 57 of the Constitution, subclause B, makes rules and orders concerning its business with due regard, and this is my emphasis, to representative and participatory democracy, accountability, transparency, and public involvement. So my focus is on representative and participatory democracy, and my submission would be by reading those two democracies into the rules, indeed, then we can come to a secret ballot vote. In addition to Section 57, there are also other rules within the rules of Parliament that indicates clearly that the Speaker does have discretionary powers when it comes to making a decision. The first rule is Rule 8, and I would like to read it. The heading is Rulings. The Speaker must perform the functions as provided for in these rules and may make rulings in applying and interpreting these rules, orders of the House, and directives and guidelines approved by the Rules Committee. That is 8, subclause 1. But there's also Rule 4, which gives the power to the Speaker to suspend or supplement any rules as he deems fit for the House at that specific time. In addition to that, Rule 26, subclause 3, which is the general authority and responsibility of the Speaker, it clearly says the Speaker is responsible for the strict observance of the rules of the House and must decide, my emphasis, on questions, which is also, which I can also provide the definition of questions, of order and practice in the House, such a ruling being final and binding as provided for in Rule 92. I also submit that Rule 92 is not of relevance at the moment. Then, in Rule 129, motion of no confidence, in particular, 129 subclause 3, it reads as follows: the motion must comply to the satisfaction of the Speaker with the prescripts of any relevant law. My submission is the relevant law is Section 57, subclause B, with reference to representative and participatory democracy, or any relevant rules and orders of the House and directives and guidelines approved by the Rules Committee before being placed on the order paper, and must include the grounds on which the proposed vote of no confidence is based. In principle, according to the Speaker, she's got no objection to a secret ballot vote. In addition to that, the papers is very clear that none of the political parties in Parliament that will participate in that motion of no confidence has objected to the secret ballot application from the UDM. So if none of the political parties have objected, those ones that will be directly affected, why then are we still wasting time? But in addition to that, let me elaborate on the elements of participatory and representative democracy. And I rely on Theonis Roux, it's part of the Heads of Arguments, in his article about democracy, and he describes it as follows. Participatory democracy is essentially about the question whether, and if so, how citizens should be given the right to participate in the making of decisions that affect them, notwithstanding the fact that basic form of political organization in the modern nation state is and likely to remain representative democracy. So why the interpretation of the rules? My submission A is because members of Parliament performs a dual function in the performance of their duties. They represent people, that is in section 42, subclause 3, by passing legislation, choosing the president, overseeing executive action, etc. But they're also members of the political parties, and we cannot ignore that. Whether they vote with their conscience, which they should, there is also still the element of political party loyalty that they have to adhere to. So how best then can the speaker find the common ground to accommodate these two notions? My submission is plain and simple, by allowing a secret ballot vote. Rule 35 of the parliamentary rules, in addition, also indicate that when a member of Parliament is absent, it is not the National Assembly that demands answers, but that member of Parliament should in fact report to the political party that he or she represents. So clearly, and we all know it is common, that the political parties play a big role, and we cannot just push that aside in the name of vote by conscience only. The authority for this is also derived from the matter Max versus Independent Democrats and Others, 2006, Volume 3, SA 112C. And that court has indicated that, 1, members of Parliament perform a dual function. They represent the party and they serve in an individual capacity. But constitutional democracy is undermined if individual capacity of a member of Parliament is not recognized. And this is what all the previous counsel before me have spoken on. Constitutional democracy is premised on a government that is responsive to the needs of citizens. What do I mean with responsiveness? It's reflected through an active participation of all the citizens, and that active participation is in essence underlined in section 19 of the Constitution, and it is also referred to by Pierre de Vos in his article, It's My Party and I'll do what I want to. But my submission with regards to this is the citizens' voices are heard through, number 1, public hearings in Parliament, number 2, hopefully, peaceful protests, and number 3, the election of public representatives. So why then are their voices not heard when it comes to the secret ballot vote through a motion of no confidence?
The 10 minutes has expired.
I thought that was 1 minute.
So we are free to interrupt you. But let me ask you this question. You say no party is against the secret ballot.
Yes.
So why are we wasting time?
Yes, Chief Justice.
Why don't they make a rule now that they agree to vote by secret ballot rather than adding to the workload we already have?
I was hoping they're going to do that before we start, Chief Justice. May I continue? Thank you. At the end of the day, it is the citizens that bear the brunt of whether the motion of no confidence will succeed or not succeed. We all know about the notion of #junk status. The exercise of political rights of citizens cannot be interpreted to participate in public hearings, in protests, public protests, etc. But when it comes to a decision like a motion of no confidence, all of a sudden they have waived their political rights to participate. And what is the effect of a waiver then? We must look at the nature and purpose of the right. It is my submission that when it comes to section 102.2, this is something serious. It's got to do with the oversight of the executive. If we say that the citizens cannot participate through a secret ballot vote of the members of parliament, then we also need to look at the length of period that they now will have to suffer, irrespective of the outcome. But also, what is the danger of the abuse? The danger of the abuse is seriously that it will impair the constitutional democracy, where it clearly says that members of society can participate in any decisions that directly have an impact on them. The Leonard Max matter also indicated that members of parliament, despite being appointed through a party, can follow their conscience. That is what the previous members have said. But in addition to what I've said, a motion of no confidence is not just members coming to one venue, which is the National Assembly, and vote. There is a debate. And that debate is clearly set out in the rules. And my submission is that, of course, a debate is not just members talking, but it is there because it's got a persuasive value. And why would there be a debate if the Constitution and the members of Parliament and everybody was of the view that we will just go there and quickly get it over and done with? My submission is there is a debate so that individual members of Parliament can be persuaded to vote either left or right. But there is also the reality that there is bound to be a time conflict between faithful to the Republic, which is part of the oath of members of Parliament, and the loyalty to the party. We cannot run away from that. And it is then the responsibility of the Speaker to find the middle ground when it comes to that. In the Mazibuko matter, paragraph 41, the court clearly held that voting on a motion of confidence is done by members of the Assembly collectively. Not political parties, members collectively. The presence of threats is there, whether we want to address it or not, whether we do not recognize it or not, it is there. And I would like the court to take judicial notice of that. But in the matter of DA versus Speaker, it was held that for Parliament to exercise its oversight function over the executive, it must operate in an environment that guarantees members freedom from arrest, detention, prosecution, or harassment of whatever nature. Absent this freedom, Parliament may be cowed with the result that oversight over the executive may be illusionary. It is my submission that when we leave at the end of this day, we shall be clear and confident that when our members of Parliament vote, all these rights that I've indicated to now will definitely be present. Again, the question was asked earlier, why are members not free to vote in an open vote? My submission with regards to that is the element of dual representation. They represent societies. Society is voters, non-voters, members that have all citizens, and it's not just members of a particular political party. And if the members will now go and vote on an open vote, and where there was a political party that have already pointed the finger towards some of their members, then unfortunately the conclusion would be that it is not the rights of the citizens that have trumped, but in fact it would be that of the political party representation instead of that of the members. So the voices of citizens would have been silenced. In the Leonard Max matter, again, the court warned against voting cipher. I hope this will not be the case. But also, again, I refer to the matter of DA versus the president, where it was held that no confidence is directly linked to belief. Justice Cameron also referred to that earlier, belief. When members vote for the president, they have to believe that this is the right person to lead this country. And so when it comes to a motion of no confidence, it's again that issue of belief. And we cannot say that political parties have beliefs. That is ascribed to individuals and not to political parties. There are no emotions when it comes to political parties. In the Ambrosini matter, I'm almost done, Chief Justice. In the Ambrosini matter, paragraph 65, the court held that the validity of the National Assembly rules depends on whether they recognize and facilitate the exercise of the individual's members' powers. Alternatively, whether they create a high risk of those powers being paralyzed. So in short, the answer is that when the Speaker received the letter of the UDM, she ought to have taken into consideration all these cases that I referred to, Section 57 with regards to participatory and representative democracy, and then she ought to have made a decision keeping in mind that the National Assembly is there to represent the people on the one hand, but also the members of parliament are linked to the political parties that they serve. And in order to come to the middle ground, the only conclusion that we can get to is a secret ballot vote.
What should he have made of the Tlowama judgment?
Chief Justice, when that matter was passed, it was a different political environment in this country.
No, I'm asking about the binding effect of a court judgment, political environment aside. Here is a Tlowama judgment that tells me as the Speaker that there is no room for a secret ballot when it comes to a motion of no confidence. What is the Speaker supposed to do? Disregard.
Chief Justice, I'm not so sure now exactly the date when the Tlowama matter was passed, but I do know that the rules of Parliament was recently adopted, which was on the 26th of May 2016.
Yeah, but my point is this. Did Madam Justice Goliath and her colleagues interpret the rules only, or the Constitution as well? Section 102. For us to say the correct interpretation depends on whether you are looking at the old rules or the new rules.
Chief Justice, there's more than enough room for interpretation in the rules that could have allowed the Speaker to find the middle ground in order to make sure that the rights of the citizens is protected the same way that the political parties' loyalty is also protected.
That I understand. I'm saying you are a Speaker, you have the Tlowama judgment. And the Tlowama judgment said, no. You can't. You can't have a motion of no confidence voted on by a secret ballot. What must she do?
She could have called for an urgent sitting and allowed the parties to vote on it. In any event, when she noticed that none of the political parties in this specific matter objected to this application, she is the chairperson of the House. She knows how to interpret the rules. She could have then said that she abide by the outcome of this court, alternatively that she grants the request, because in any event, the affected parties have no interest in this matter. My submission is, unless the element of dual representation of members of parliament is incorporated in the rules, the motion of no confidence will just become a paper power and not really the power that we have envisaged in the Constitution. In the Mazibuko matter, even though it was part of the minority judgment, paragraph 45 indicated the better view of this right is accorded to every member of the National Assembly. So everything points towards the rights of individual members. Of course, that relates to conscience, but my submission is, in addition to that, the rights of the citizens must, at the end of the day, prevail. I would like, in conclusion, provide this court with something to think about and take judicial notice of it. I can provide this information. It's just few numbers. On the 6th of May 2009, Chief Justice Langa was the presiding officer at Parliament when 393 members of Parliament were sworn in. Then there was a proposal that Mr. Jacob Zuma become the president, and there was a counter proposal that Mr. Dandala become the president. The result of that was that Mr. Dandala got 47 votes and Mr. Zuma got 277 votes. Now remember, I said earlier, 393 members were sworn in. They were in the House. The election took place. And then the result came, 324 members voted by secret. We don't know who voted how, but at the end of the day, the minutes reflect that 69 members of Parliament did not vote. We don't know who those members of Parliament were, from which political party. I cannot elaborate on that. But the issue that I would like to leave this court with is, if in 2009 there were 69 members that was not held accountable, and we were all happy, we got a president after the elections, why would this now be an issue? Thank you, Judge.
Thank you, Ms. Adams. Thank you very much. Mr. Bartlander, I think you're next.
Two.
Just for the record, yours is 5 minutes, not 10.
That is so, Chief Justice.
Thank you.
Chief Justice and members of the court, I propose to address three matters in my submissions, oral submissions to the court. I'm first going to say something about judicial overreach and the separation of powers. Then I'm going to say something about the oversight function of the National Assembly. And then thirdly, I will address a matter which was raised by Justice Kampepe and by you, Chief Justice, the question of accountability in parliamentary processes. So to come to the first, and separation of powers or judicial overreach, which we read about a lot, I submit that courts in a constitutional democracy are and should be concerned to avoid judicial overreach, because the judiciary is one of three branches of government, and it's legitimate and appropriate for the courts to be concerned not to take over the functions of the other two branches. That, however, doesn't mean that the conduct of the other two branches is insulated or immunized from the judicial function. Because what the courts do is they ensure that the conditions exist under which the other two branches can properly perform their function. What the courts do is ensure that the appropriate conditions are created. That's not overreach, and neither is it a breach of the separation of powers. It's simply the courts exercising their powers, which are their function and their obligation. And we see that in many situations. We see that in relation to the administration. Our courts don't take over the decision-making of the administrators or the executive. They ensure that a proper procedure is followed. They ensure that there's fairness and rationality in the process. And they ensure that the decision-making is in accordance with what the law requires, including the Constitution. But the courts, in other words, the courts create the condition for appropriate executive and lawful executive and administrative decision-making. But the courts don't make the decisions themselves, except in very exceptional circumstances. Similarly, in relation to the legislative function of Parliament, the courts ensure that the process is correct. We think of Doctors for Life, we think of land movement of South Africa, where the court said, no, this law is invalid because the process was wrong. We think, Justice Jafta points out with respect correctly, that Parliament is the master of its own procedures. That, of course, is so. But what the courts do is ensure that the process is in accordance with what the Constitution requires. And so we have a case like Ambrosini, where Parliament, exercising its Section 57 power, or purporting to exercise its Section 57 power, made a rule which said that you can't introduce a private member's motion or a private member's bill other than with permission. And this court said the Constitution is silent on that matter. It doesn't say anything about it expressly, but it's clear from what the Constitution requires, the nature of the democracy we have, that members of Parliament ought to be able to introduce private members' bills. And so this court said that the rule, the then existing rule, was invalid. Didn't make the decision, just created the conditions under which Parliament could carry out its constitutional function. We see the same when the courts deal with the contents of legislation. The courts ensure that the laws are consistent with the Constitution. The courts don't write the laws, but the courts ensure that the conditions are met. And the same applies to, if one comes now to the present situation, to the other role of Parliament, to the oversight role of the executive. There again, the function of the court with respect is to create the conditions under which the oversight role can be properly and effectively exercised. And so we see Mazibuko versus Sisulu, where the court said this is how the oversight function must be exercised in relation to votes of no confidence. Again, this shows us the courts ensuring the conditions for oversight by Parliament, but not purporting to exercise that oversight themselves. And this case has potentially momentous consequences, but it's no different from any of the cases I submit that go before. It's about creating the conditions under which Parliament can exercise its constitutional function of oversight through voting on a motion of no confidence. So this case is not about people seeking to obtain through the courts what they can't obtain through the democratic process, which is the criticism which is usually made. It's about enabling the democratic process to function in the manner contemplated by the Constitution. So it's not a case about the courts trespassing on Parliament's terrain. It's about ensuring that the terrain is such that Parliament can exercise its constitutional function.
Well, the 5 minutes is up, but how far can the court go? What is it that is constitutionally permissible for a court to do? Let us assume that we arrive at the decision that it's either required or permissible.
Yes.
Need we do more?
It will.
Should we order to the National Assembly or the Speaker to do anything specific, or is it enough just to clarify the law?
Well, I submit that
Would it not amount, in other words, to judicial overreach if we take it a step beyond saying, you know, you are either required or permitted to do this?
if the court concludes, if the court concludes that in relation to a motion of no confidence, a secret ballot is required in order for the oversight to be effectively exercised, then this court, I submit, has two options. Either it can simply make a declaration and say this is what is required and expect that the Speaker will comply with the declaration issued by this court, or it can take a step further and order the Speaker to hold a secret ballot. But we expect and trust that in our constitutional democracy, when the Speaker is told by the Constitutional Court this is what is required, the Speaker will act accordingly.
The additional order, would it not amount to overreach, though?
Well,
does it not assume that the Speaker is not going to do what the law as clarified requires of her to do? And does that not amount to overreach now? We don't think you can be trusted to do the right thing. We're going to force you to do it. Is that not what it amounts to?
Well, Chief Justice, there is a well-established principle of comity between the different branches of government, and each of them expects the other to do what it is required to do, and doesn't assume that it won't. And my submission is that, well, it would be an astonishing matter if this court were to say, in terms, this is what the Constitution requires, declare that, and the Speaker then didn't comply. If that happened, we would be back in court again, of course. And one must assume that the Speaker will do what the highest court tells her is her duty.
I wanted help from you, a clear position in relation to whether taking it beyond that does not amount to judicial overreach. Does it not amount to intruding into that space that is reserved for the National Assembly? If you take it beyond that.
Justice Mogoeng, it's a bit like the matter that was debated in the treatment action campaign case some years ago, where there was a question about the extent to which a court will make mandatory orders, in that case also on another branch of government, on the executive. And in that case, the court made a mandatory order, but it made a mandatory order in particular circumstances where there was a threat to the lives of children, where there had been a previous refusal to carry out a particular program, and under those circumstances the court issued a mandatory order. It may not be necessary or appropriate in this case. I sound like I'm hedging my bets, because it's very difficult to draw that line.
You are not in a position to say whether it trenches separation of powers or not,
no,
to take it beyond declaring what the correct legal position is.
My submission, Chief Justice, is it would not improperly trench on the separation of powers, but it may nevertheless not be appropriate to make such a mandatory order because of the respect for of comity between the branches. And the court may stand back from that and say this is not necessary. But in an appropriate case, let me put it differently. If the Speaker said, well, I don't care, and I'm not going to do it, if the court issued a declaration and the Speaker said, I'm not going to do it, I don't care, then this court would issue a mandatory order. There'd be no breach of the separation of powers.
Or if, to take an awkward position, if she had said it already in her papers,
yes.
Even if the court were to say that I'm obliged to do this, or I have the discretion to do this, I'm warning you people in advance, I'm not going to carry out that order. That's a different issue altogether. But when there is nothing to suggest that she is disposed to disregarding a clearly articulated position, then I'm not too sure whether it doesn't amount to overreach.
Well, Chief Justice, let me pin my colors to the mast, where the Speaker has said, the reason I'm not allowing this is because I believe I'm not entitled to allow it, but in principle I've got no objection to it. If the court says, we're telling you now this is what you're required to do, that would be sufficient.
Mr. Butler, and what if the court holds that it's a discretionary power?
It's different if the court holds that it's a discretionary power. The premise of my submission is that the court will make it clear that the Speaker is obliged to act in this manner, that it is a constitutional obligation that there should be a secret ballot because of the requirements of the Constitution, and I'll say something about that in a moment. But I certainly an order by this court simply saying, well, you've got a discretion, exercise it, would take us nowhere. The court ought to go further, I submit.
Why?
Because, Chief Justice, the discretion, if there is one, is a discretion. It's not this usual sort of discretion where you can do A or B or C or D or E, and the holder of the power says it's for the holder of the power to decide which is the best of those five. This is a case where you can either do A or B. You can either have a secret ballot or you can have an open ballot. And if you have an open ballot, there will be a failure of oversight. And therefore, because in the situation of an open ballot, members of Parliament will not be able to free to exercise their oversight functions properly.
Now, let's talk about that. I don't understand the submission. If the National Assembly or the Speaker has a discretion to decide whether the voting will be by secret or open ballot, isn't the discretion for them to exercise? What would explain this court's position that, well, you have a discretion, but we are telling you now that it must be by secret ballot? Why would you do that? What entitles us to do that? What empowers us to do that? If it is not obligatory, it's only permissible. Why should the court exercise that discretion on behalf of the Speaker of the National Assembly? Which law allows us to do that?
Sorry, the Rule 102, Rule 103 gives the Speaker the discretion to choose a different method, an appropriate procedure for voting on a motion which is before the National Assembly. It gives a discretion to the, what it says is, at a sitting of the House in a chamber where an electronic voting system is in operation, unless the presiding officer directs otherwise, questions are decided by the utilization of the electronic system. Now, there may be various situations in which the Speaker may say, I'm going to consider directing otherwise. In that sense, there's a discretion. But the discretion where the case is a case of a no-confidence motion, the manner in which she has to exercise the discretion is dictated by the Constitution. And the Constitution says for a no-confidence motion, there must be a secret ballot, because otherwise the process is frankly useless.
I'm sorry to detain you, Mr. Butland. I thought whatever interpretation you're urging us to arrive at would be premised on the Constitution, not the rules.
Yes.
But if you veer off to the rules, that's what complicates the situation.
With respect, no, Chief Justice.
I thought you're always going to say or determine whether the Speaker is under an obligation or has a discretion to have this vote conducted by a secret ballot based on what the Constitution says is the correct method to adopt. Yes. But once you veer off to the rules now, it looks like some fairly weak ground that you want to base your case on.
My case, Chief Justice, is that Section 42.3, Section 55 of the Constitution require that a vote on a no-confidence motion must be by way of a secret ballot. That is what drives the case, and that is what drives the obligation of the Speaker. So when the Speaker receives a request and she's asked, please have a secret ballot, or when she considers whether to order a secret ballot, she can go and look at the rules, but she's got to be, her decision has to be determined by the Constitution, and the Constitution allows only one thing. That is my submission, Chief Justice. I'm sorry if I've been unclear on that.
Now I understand you.
As the Court pleases. I eventually get there, Chief Justice.
That, Mr. Butler, sorry to tax you. I'm interested, if we don't sustain your case-ax and some of the other parties and the UDM's main submission, if we find that there really is a discretion
Yes.
on the part of the Speaker, then I'm interested in your reply to the Chief Justice as to what further relief the court might have to give.
If there really is a discretion, then it's a discretion of the thinnest and narrowest kind, and it's the decision on which is driven by the Constitution. The exercise of the discretion is driven by the Constitution. And it brings you to the same result that the Constitution tells you that the only permissible way to exercise the discretion is to order a secret ballot, because otherwise the oversight function will fail. And so you get to the same result because you get to a situation of no other outcome is possible. The Constitution determines what the outcome must be, and this court, with respect, will put us all out of our misery and say that, rather than wait for the matter to come back on another occasion.
I'm sorry, forgive me for my slowness, and I don't know if my brother had finished. So it's a discretion, but it's not a discretion.
No, Chief Justice, I'm answering Justice Cameron. If Justice Cameron says if the court decides that there is a discretion, then what does the court do? And I'm saying if the court decides that there is a discretion, it then says to the Speaker, you have to exercise this discretion in a manner which is consistent with the Constitution. The Constitution allows only one outcome to your exercise of your discretion, and therefore we make an order accordingly.
In other words, the Constitution does not allow you to choose. The Constitution obliges you to hold a secret ballot.
Yes, the Constitution may allow you to hold non-secret ballots in some other situations which you face, but in the case of a no-confidence motion, it allows only one answer. Assuming you've got a discretion, and you can have a number of different situations in which you have a discretion now. A no-confidence motion, an appointment of a board, or this or that or the other. What the Constitution says, to the extent that you've got a discretion, when it comes to a no-confidence vote, there's only one way in which you can lawfully exercise it.
Let me just get it clear in my mind, Mr. Butler. When it comes to a motion of no confidence, what option does the Constitution point to, according to you?
It allows, whichever route you follow, Chief Justice, it allows only one outcome, which is a secret ballot. And whether you get that route by saying there is no discretion at all, or whether you get that route to say there is a discretion, but the Constitution determines the outcome of the exercise of the discretion, you get the same result, that it's the only permissible outcome.
Mr. Butler, I'm sorry to intrude. I'm still not happy.
You're doing that, Justice Cameron.
Let us assume that the court says there isn't only one answer, and there is a discretion, and the incumbent Speaker has to weigh the options between a motion of no confidence as between secret ballot and not secret ballot. What do we then do?
Well, that's what I submit most vigorously. The court will not a conclusion the court should not arrive at. If the court, contrary to our submissions and contrary to the submissions of others, says there is a discretion and there are many things which you can lawfully do, then the court would presumably wait for the Speaker to exercise her discretion. But if there's only one thing which she may lawfully do, then she must do that thing.
Well, Mr. Butler, as I understood the alternative argument of Mr. Mpofu and the main argument, I may have got it wrong, of Mr. Toby, it's that the mere suggestion of any risk of intimidation or coercion or pressure makes only one outcome possible. So that's different from what you've just said. You've suggested that we should, if we find a real discretion, we should let it go back to her. They say that in the present circumstance, it's incontestable that there's at least a suggestion of some intrusive force being brought to bear on the conscience of MPs, and therefore we must mandate a secret ballot.
Justice Cameron, I think I'm not understanding you, or perhaps I'm not speaking clearly enough in my answers. If the court says there is a genuine discretion, but it finds that the circumstances are such that a genuinely free vote will not be possible if it is an open vote, then there's only one possible answer, which is that there must be a secret ballot. And that's the only
I
permissible
thought the Chief
exercise.
Justice wanted to know whether that answer wouldn't be intrusive.
No, with respect, no, because all the court is doing is interpreting the Constitution, and that's the job of this court, and that's what the court does. It wouldn't be. It may, whether it does it by way of a declaration or a mandamus doesn't make much difference, but the court needs to speak clearly and say to the Speaker, this is what has to happen. This is because, and why does it have to happen? Because it's what the Constitution requires.
I hope it will become clearer to me as we go forward, but I honestly don't understand how a court can arrive at the conclusion that you have a discretion, and before you even exercise that discretion, the court itself comes in and basically force you to exercise your discretion in a particular manner.
Well, because that happens in exceptional cases, in administrative law cases, Chief Justice, where the court says there was a discretion, but only one outcome is permissible from the exercise of that discretion. The outcome is only one possible outcome. It's a foregone conclusion if you do it lawfully. You can only do it this way. And then the court sometimes steps in and says, well, I'm telling you, this is the only way it can be done.
The discretion in this case would still be the Speaker's or the National Assembly's to exercise.
If one says there's a discretion, yes. But the court, I submit, would say to the Speaker, this is the only way in which it can lawfully be done. Because otherwise you're not assisting the Speaker. And you're not assisting any of us with respect.
Can you just cite me some authorities that says you have a discretion, but you must do it this way?
Well, that's why the court will step in and make the declaration. What the court does is it steps in for the Speaker effectively. It says there is, if discretion is found, it says the discretion, but it's a discretion, but there's only one outcome. So we say this should be the outcome.
Can there be a discretion and there is one outcome? I don't understand, Mr. I'm sorry to detain you, but how can we say you have a discretion? I thought if you have a discretion, you have a choice between saying secret ballot or open ballot. That's the discretion, or something else.
Yes.
But if you don't even have a choice, how can it be a discretion?
Chief Justice, if you notionally have a discretion, if the Speaker has to make a decision as to whether there will be a secret ballot or an open ballot, and if she exercises her discretion in one way, it will be lawful, and if she exercises her discretion in another way, it will result in an unlawful outcome, then she has to exercise her discretion in the lawful way. And that's all the court would be doing in making a declaration, is saying, this is the only lawful way this power can be exercised. One very often sees a situation where there's a notional discretion. You can do A or you can do B. But to do B would lead to an unlawful result. To do A would lead to a lawful result. You've got to do A. And a court can say you've got to do A because B will be unlawful. That's discretion in that very narrow sense. That's why I say it's a thin or narrow discretion. It's a notional discretion, but it's not a real discretion, because the Constitution tells you how you must exercise your power.
Bartlander, if you can just clarify one aspect for me. If you look at the notice of motion in paragraph 3, the applicant seeks a declarator to the effect that the Constitution requires that the motion of no confidence in terms of Section 102 of the Constitution be decided by secret ballot. Assuming, are you there?
I'm sorry, I've lost the page. I now have it.
It's on page 2.
Here, paragraph
3.1.
Yes.
The first declarator. If we are minded to grant that declarator based on the purposive interpretation of the Constitution,
yes,
do we even need to go to the second declarator in relation to the National Assembly rules?
No need to go there, Justice Nkabinde. That disposes of the matter.
I beg your pardon?
That disposes of the matter. If you're inclined to 3.1, then you don't need to go any further.
And if I understand you correctly, you don't even need to get to the issue of the discretion of the Speaker?
That's correct, Justice Nkabinde.
Thank you.
So can I then
We've
say
added 20 minutes to your time. How much more time do you need to wrap up? I know we are to blame for you taking as long as you have.
Could I have 10 more minutes, Chief Justice? And I will skip most. What I had to say about the oversight function, I think, has been said by many other people, and I don't see any purpose of in repeating all of this. Can I just say something about some of the matters which have been raised with other counsel and which I would like to respond to? The first thing I've submitted is, and the core submission is, that the function of the court is to create the conditions in which members of the National Assembly can carry out their constitutional duty of oversight, under 42(3) and under 55, and that the only way to create that condition is to allow a secret ballot. Now, a member of a party who votes contrary to the instructions of his or her caucus may or may not be subject to some sort of criticism within the party, but the one thing that the party can't do, and that's to respond to the issue raised by Justice Zondo, the party can't remove that member from Parliament. The only way the party can remove that member from Parliament is by expelling him or her from membership of the party, because the termination of membership of the National Assembly is dealt with in Section 47 of the Constitution, and one of
Section
47(3). says a person loses membership of the National Assembly if that person A, ceases to be eligible, for example, criminal offences, insolvency and so on, not a citizen. B, is absent from the Assembly without permission in circumstances for which the rules and order of the Assembly prescribe loss of membership. Or C, ceases to be a member of the party that nominated that person as a member of the Assembly. And so if there is no procedure for changing the list, the remedy which the party has is, next time around we won't put you on the list again. But the notion that you can be expelled from the party and thereby expelled from Parliament for acting in accordance with your constitutional obligations, I submit, is foreign to our Constitution.
Well, can they say, no, if you are a disciplined member, we want you to go now and to be a deputy mayor somewhere, or a mayor somewhere. You are best suited for that responsibility than being a backbencher in Parliament. You are being wasted. Can't they do that?
No, they
can't.
Can't
they make their own internal arrangements?
They can try to persuade you. They can try to give you a very attractive
They can't redeploy you.
They can't redeploy you unless you agree to be redeployed. There's no concept of redeployment in our Constitution for members of the Assembly. They can offer you a job as an ambassador in Paris and hope that it's attractive and that you'll go. But if you say, no, actually, I'm going to hold on to my seat as a backbencher, there's nothing they can do short of expelling you from the party.
So you can even vote by open ballot then? Nothing will happen?
No, because we know what's going to happen. They're going to be expulsions from the party. That's the fear. The fear is that if there's an open ballot, you will be expelled from the party and expelled from Parliament through that mechanism. And it's a legitimate fear. And that's why there needs to be a secret ballot.
Sorry. Would that be consistent with the Constitution then, Mr. Butlander?
The expulsion.
For the party to expel the member for the only reason that he acted as required by the Constitution of the country?
Justice, it's with respect, a very interesting question and will lead to a lot of litigation which will be back in this court 3 years from now. Meanwhile, the horse is bolted. And if the court sees a situation in which there is a risk of unconstitutional action, the court will say, no, we're not going to, the Constitution doesn't contemplate that. The Constitution doesn't enable unconstitutional action, it prevents unconstitutional action. And so there is, with respect, you're correct, that theoretically there could be an open vote, there could be expulsions, disciplinary hearings, expulsions, there could be challenges to those expulsions, and they would get to this court about 2 or 3 years from now. That defeats the whole purpose, that defeats the accountability which the Constitution requires. That would be fundamental, it would render worthless Section 102 of the Constitution. It would defeat the accountability which is required of the National Assembly. That's my submission.
I'm sorry, Mr. Butler. So are you saying to us, in the context of this case, that actually members of Parliament should have no fear as to which way they vote, even in a no confidence vote, other than, because nothing can happen to them other than that they may be expelled from the party to which they belong. So other than that, you say constitutionally nothing can be done to them by their party.
I'm saying, Justice Zondo, that they should have no fear that they will be punished anyway for exercising their constitutional obligations, whether through expulsion or through any other method.
Theoretically or realistically speaking?
That is realistically speaking, because if there's a secret ballot, then there will be no risk.
Secret ballot.
Yes.
You're talking about a secret ballot.
Yes, there will be no risk of punishment, and that's the whole purpose of a secret ballot.
No, I'm sorry, we might have misunderstood each other. Yeah.
I'm sorry.
No. Part of the reason that has been advanced by the UDM and I think maybe other parties for why we should interpret the Constitution in such a way that we say it requires that the ballot be a secret ballot in the context of a no confidence vote, is that otherwise certain members of Parliament will be scared to vote in the way that they otherwise would like to vote.
Yes, Justice.
Because there could be victimization, if you want, by their parties. But you are here to say, really, they should not be scared of anything. Is that what I'm asking?
No, I've obviously not been clear, Justice Zondo. No, I'm endorsing what they say. And the reason for a secret ballot is to prevent people fearing victimization and therefore voting not in accordance with their consciences and their constitutional obligations. If there's an open ballot, there is a material risk, and we know that that's a material risk, that people may feel intimidated and not vote what they believe is right for fear of the consequences.
Yes, but I'm trying to understand you. You said if you belong to Party A, and Party A wants you to vote in a particular way, and in an open vote, you vote in a different way, you said that party can't do anything to you other than expelling you from the party.
And that is the fear, Justice Zondo.
Yes. So, but leaving out the fear of being expelled, which is quite something, because then you would lose, I think, membership of Parliament, isn't it?
That's correct, Justice Zondo.
Leaving that out, what you are saying is, if they fear anything else, really, from within being a member of Parliament, there is nothing to fear. They might fear, but there would be nothing to fear.
No, I'm not going that far, Justice Zondo. There are various other forms of reprisal which can be taken. There are forms of reprisal, a whole range of reprisals which can be taken.
Okay.
One of the forms of reprisal is expulsion.
Yes.
But of course, it's not the only form of reprisal. And there should be no fear of reprisal when one exercises the oversight function of Parliament.
Yes. But of course, that expulsion from your party is quite a serious thing.
Very serious. Very serious. And that's one of the fears. Not the only fear, but it's one of the fears. And it's noteworthy with respect that although the issue is raised directly in the founding papers by the UDM, the Speaker doesn't speak in this, but the President doesn't say nobody would ever be expelled for that. He says, well, that's a possibility, or it's a theoretical possibility. But what he doesn't say is that's such a serious thing that could never happen, because we know it could happen. So finally, on the question...
I'm sorry, Mr. Butler, could I trouble you even more? Much has been spoken about the personal risk and the immediate factual context. But even if that wasn't so, isn't there a deeper institutional risk? Yeah. Namely that if the members of a ruling party doesn't feel free when it comes to the oversight role of the National Assembly, if they don't feel free to vote according to their conscience, then the constitutional structure our constitutional structure is undermined, because then you don't have three arms of government, you basically have only two. And we've seen the effect of that in this court, because so many cases come to us now because of the allegation that the oversight role of the National Assembly is not done as it should be.
With respect, that is said, I'm grateful to Justice Froneman for raising it. It was the point really that the purpose of oversight is most effectively served by a secret ballot. If there's no secret ballot, the oversight function fails, and that means that the Constitution fails. And we have seen, Justice Froneman is more polite than I am, we've seen just 2 months ago what happens when the oversight function of Parliament fails. There was a crisis which this court had to remedy. And so the function of oversight is fundamental to the operation of the institution, our Constitution, not only at a theoretical level of constitutional structure, but also in terms of people's rights on a daily basis. And that's what we saw in the Sassa case. We saw in the Sassa case that the failure of oversight created the material risk that recipients of social grants would not get the grants to which they were entitled. That was the concept. Why did that happen? It happened because oversight failed. And the court, I submit, will not readily allow that. Can I come to the final point, Chief Justice, about accountability? Justice Kampepe raised the question of whether accountability and openness require open votes. And the answer to that, I submit that there is indeed a tension between the principle of accountability and a secret vote. But the accountability, of course, is not only to members of Parliament or the public, there's also the accountability of the President to the National Assembly, and the President's accountability is undermined if there's not a secret ballot. That accountability can't function unless there's a secret ballot. As far as the accountability to the public is concerned, the balance has to be drawn. When it comes to portfolio committees, they have to be open to the public. That's provided by Section 59(1)(b) of the Constitution. There, the Constitution says explicitly, we will have an open meetings, notwithstanding the fact that this may inhibit people. But when it comes to a vote of no confidence, which is the highest form of oversight, this is not stipulated. The mechanism, and we submit, and this is my closing remark or submission, the mechanism of oversight is likely to fail completely if there is not a secret ballot. That has consequences for our constitutional structure, for the people of South Africa, and we submit that the very nature of the mechanism, of the no confidence mechanism, requires a secret ballot, because without a secret ballot, the no confidence motion is likely to be useless or ineffective, and the most important oversight function as a result is likely to fail.
Mr. Badlender, isn't there an inarticulate assumption there that the members of the National Assembly will always be acting properly? What if we take a situation where the National Assembly, or at least the majority of them, for totally improper reasons, were to want to remove an otherwise upright, squeaky clean president? I'm making no pronouncements on or with regard to our president.
Yes.
Would we, as the general populace, not be interested to see publicly who of our public officials, or rather our public representatives, have chosen to vote out of office this squeaky clean president?
Justice Madlanga, yes, we would be interested to see that, and that is why I say the two principles are in tension with each other: the principle of openness and the principle of effective oversight and accountability. And my submission is that what the Constitution prescribes is it prescribes really the ultimate test of accountability, the no confidence motion. That's what this court has said is the most important mechanism for accountability, and it is so important that that should function effectively that we are willing to pay the price of saying, well, we won't know who voted for which, rather that than have an accountability mechanism which just doesn't work. That's the price we pay, and that's the price the Constitution, I submit, requires. Thank you, Chief Justice. Thank you for your patience.
Thank you very much, Mr. Badlender. Let me check this next. Mr. Manager, I think you are next.
As the court pleases, Chief Justice, Deputy Chief Justice, and Justice of the Court, in our written submissions, we indicated that in our submission on the proper interpretation, the Constitution either requires or permits a secret ballot. In other words, provides a discretion on the part of the Speaker. But we focused in the written submissions on the discretion.
Maybe you should shift the mic directly to your... Yeah, thank you.
So we focused in our written submissions on the discretion on the part of the Speaker, and I wish to focus in my oral submissions in the first 5 minutes on why we also support the main relief that the UDM seeks, the primary submission that the Constitution requires a secret ballot in the case of a motion of no confidence. And I will refer to provisions of the Constitution that we submit support that interpretation, and the principles underlying principles of the Constitution that we submit support that interpretation. And then I'll deal in part with some of the questions that arose that were raised as issues that might undermine the interpretation that we submit Section 102 bears. My learned friends have referred to Section 1 of the Constitution, which is also a section that we refer to, especially Section 1C, which talks about the supremacy of the Constitution. But in addition to that, I wish to refer the Court to Section 2 of the Constitution, because that section says that this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and in the last part says, and the obligations imposed by it must be fulfilled. And we emphasize that last part of Section 2, and we emphasize it in the context of the obligations placed on the National Assembly by Section 42(3) of the Constitution and also Section 55(2) of the Constitution. And we submit that in light with the judgment in Mazibuko, when one interprets Section 102, that must be done in the context of the interrelated provisions of the Constitution, and we identify Section 1, Section 2, 42(3), and 55(2). Now, Section 42(3) has received treatment before the Court, and that is that it requires parliamentary oversight over the executive, and this Court has said that constitutional obligation must not only be fulfilled, but must be fulfilled effectively, and has given meaning to what that means, and that is that the Section 102 is a vital tool with which the National Assembly holds the executive to account, and it uses the description to keep the executive to account. And we submit that the executive, in the form of the president in this case, can only be kept to account if there is a potential of a vote of no confidence returning a result which reflects the conscious choices of members of the National Assembly in line with what they believe are the constitutional duties that they carry. And that once that is undermined, as Justice Foreman pointed out, the constitutional scheme collapses, because there's no reason why the executive should be kept on its toes, as it were, to account to the executive. And like the other of my learned friends that went before me, the secret ballot provides the only real mechanism that could provide the condition, the security that members of parliament require to exercise their votes according to the dictates of their conscience. We're not submitting that all members of the legislature are spineless, or do we proceed to make the submission on that assumption. But what we do say is that when the Constitution says all members of the National Assembly have an obligation as a collective to hold the executive to account. It means members who have spines and members who don't have spines. If that were to be the case, all of them have the obligation equally, and all of them have to enjoy the protection of the Constitution. And it's in that light we submit that Section 102 must be given meaning.
Should you be there? Your 5 minutes is up.
Yes.
Should you even be there as a member of parliament if you don't have the spine?
Chief Justice, that's a question.
Shouldn't we rather allow you to be removed so that the public knows the quality of people who are represented?
Not so, Chief Justice. I mean, given first the fact that we are a pluralistic society, multi-party, and all of that, but that's a tempting question and a tempting proposition to reflect on. But one, without disrespect, can postulate the position of judges. Judges take the position to serve the public, to serve justice, and take an oath. But we accept that they're human beings, and in order for them to give unpopular decisions, they need security. And that is why the Constitution guarantees judicial independence by providing security of tenure, so that sitting as justices, you are enabled to make decisions that you would otherwise not make had you not enjoyed their protection. And I say so with great respect.
Well, no. That presupposes that the only danger out there is being removed from your position.
No, not so.
There are more serious dangers, believe you me.
Indeed, but it's because of the multitudes of dangers that the Constitution can't always foresee and provide for, that instead it underpins the independence with proper safeguards under the Constitution. And so the exercise of oversight over the executive, which the Constitutional Court has said, in effect, the National Assembly, and by extension Parliament, serves as a watchdog because it must control how resources are expended by the executive, and so on and so forth, and how they deploy the powers that they're given. Now, it could very well be that in a motion of no confidence debate, the issues hinge on the manner in which the executive deploys resources, or it may implicate self-enrichment, and so on and so forth. Members of the National Assembly have to have, at the very least, the minimum guarantee that they can vote with their conscience without the potential of any risk to, as the Chief Justice put, not only removal but all other consequences that we're not able to contemplate.
All other perceptible consequences.
Other perceptible consequences. So it's that spectre which was identified in the case involving the removal of the members of the EFF from the chamber, from the assembly, that it's the spectre, it's merely the spectre, and I think it was Justice Madlanga identifying the point, that what you're really concerned about is the spectre of a potential adverse consequence. Not that the consequence is proved, it will manifest, but the mere spectre which may hinder how one discharges their constitutional function is what the Constitution guards against. So because Section 102 is silent, it doesn't say, unlike in the case of the election of the president, where it's a contested election, doesn't prescribe that it will be by secret ballot. It leaves it to this court to give it meaning, and to give it meaning in the context of the other related constitutional provisions. And we submit that the better constitutional meaning, which advances constitutional obligations, which the Constitution admonishes us in Section 2 must be fulfilled, is one which provides for a protection to members of the National Assembly, and that is a secret ballot. So we submit that the primary submission by the UDM must succeed. And
while you are there, is your primary submission a discretion or obligation? I know what the UDM's primary submission is.
It's our primary submission that it is obligatory.
Oh, so was that your initial position?
Our initial position, as I explained earlier, Chief Justice, is that we said it's either required or it's permissible. But in our judgment, we thought in the 20 pages that we had to address the court in writing that the UDM had fully addressed the question of required, and we focused on the discretion. And we concluded in our written submissions that our focus in these submissions has been on supporting mainly the alternative relief in paragraphs 3.2, 4, 5, and so on, which is the discretion. But we never flinched from supporting the primary submission which the UDM make. And that's why I took my non-injury 5 minutes to support that primary submission. And we submit, like our learned friend, Mr. Badlander, for KZAC, that there are trade-offs, of course, and the submissions are made by UPM about the loss of transparency. And questions have been asked also from the Chief Justice's point of view about, but what about in other instances where you have to exercise oversight, but you can't really require a secret ballot? Now, we submit that the loss of transparency is limited, and as against the loss completely of effective oversight, we submit it's a proper balance. Now, I say transparency, the loss of transparency is limited because we're not asking that the debate take place in camera. So during the debate on the motion of no confidence, the debate will be transparent. The public will see what it is that different members of the political parties say underlie the motion of no confidence. The only thing that is secret is the ultimate decision on what the result should be on the motion of no confidence. So it's not a complete loss of transparency. But even then, Chief Justice, the Constitution itself accepts that those trade-offs are acceptable in certain instances, and that is why it specifically prescribes that for the appointment of a president, for the speaker and so forth, you can have a secret ballot. So it's a trade-off that is constitutionally acceptable. And we submit that there should be no difficulty here by reason of a loss of transparency.
On a lighter note, Mr. Manager, it's a very interesting case. It's almost as if these opposition parties want to protect the ruling party members and the members of the main opposition party who are not involved in this thing. But you are primarily concerned about the majority party in some strange representative capacity.
Well, I can't speak for the political parties. At least I speak for an NGO. So the NGO is animated by the Constitution, and once the Constitution vindicated, and that is why we're making the submissions we're making. And we also submit in part answer to the question about holding accountable in the open, that often that involves questioning and deliberation, and it's one step removed from the final decision-making on whether there must be a removal or otherwise. And it is, we submit, the critical point of deciding to remove where the maximum protection affordable under the Constitution is required, because it is there where one may be hindered in voting according to their own perception of what the Constitution requires of them because of the potential consequences that may befall. And in support also of the submission by the UDM, we say that the underlying rationale for a secret ballot where you have a contested election of the president or the speaker is present, and even perhaps more heightened, as the Chief Justice remarked, where you're voting on the removal of the most senior member of the executive and often the most senior member of the political party. And if I may deal just with one aspect in relation to discretion, and that's the question of remedy. I know I'm putting myself into a very contentious area, but let's say 1 cent's worth about that. Our understanding of the UDM case is this, on the question of discretion, is that the Speaker misconstrued her powers or the nature of her discretion when she said, I don't have a discretion to consider whether to have a secret ballot. Now, assuming that the discretion exists and submissions have been made in support of that, we would submit that once this court finds that that decision of the Speaker was invalid and unconstitutional, which is what the UDM asks, then the remedial powers of the Constitutional Court in Section 172 kick in that the court can now inquire on what a just and equitable or appropriate remedy may be in the circumstances. And as my learned friend, Mr. Butlander, has said, in the context of administrative reviews, ConCourt makes very clear that when the court exercises the just and equitable remedy powers under Section 172 of the Constitution or Section 8C of the Promotion of Administrative Justice Act, it doesn't trench on separation of powers, because granting effective remedy or remedies that are required by the Constitution falls within the province of the Constitutional of this court. And so if the court were to accept the proposition that this confluence of factors here make this an exceptional case, we would submit that directing that the Speaker, following upon a declaration that her finding that she lacked discretion was unconstitutional, that the directions that she makes arrangements for the vote to take place by secret ballot is not trenching on separation of powers.
Well,
but it has to be an exceptional case.
Sure. Well, that remedy, does it have to be separation of powers sensitive, or do considerations of separation of powers always fall by the wayside when you make a remedy envisaged by Section 172?
No, they do. They are part of the considerations, because by its nature, substitution is encroaching on another. So I accept that by nature what we're asking of the court is, this is the case which justifies that encroachment.
Now, if there is no indication whatsoever from the Speaker or the National Assembly that once the legal position has been made clear, there won't be compliance, why should the court act as if there's some indication that the Speaker is disinclined to do what she would then be knowing to be the right thing to do?
We accept that.
Is that not a typical case of poking your nose where it doesn't belong, where it's not permitted?
With respect, not where the Speaker tells the court that, and here I stand to be corrected, whether she's speaking in her personal capacity or speaking in her capacity as the Speaker. But she says to the court, I have no difficulty with a secret ballot. The only thing the only view I hold is I don't have the power. Now, once the court says you do have the power, it does seem to us, in our respectful submission, that then she has no objection to having a secret ballot.
No. If she says, I'm not averse, I think those are her words.
Yes.
I'm not averse to holding this motion by way of a secret ballot. And you say, okay, since you didn't understand what the law requires of you, this is it. How can you then take it a step further? When she's making it clear, if you if you tell me that I'm supposed to arrange that the motion be held by way of secret ballot, I'll do that. And now the court ignores that and say, in fact, you are hereby ordered to do X, Y, Z. Is that not an authorized encroachment?
Chief Justice, we would submit only that if it is a remedy which is justified by the circumstances, exceptional circumstances, that would still fall within the province of what the court is entitled to do. But of course, the court will do so sensitive to the question of separation of powers. Unless there are other questions, I think.
Does the administrative law principle of substitution, does it really guide us here in the light of the principle of comity between the arms of government?
Justice Chapter, this is, of course, is not an administrative dispute before the court, but we do submit that the powers to grant an appropriate order which is just and equitable under Section 172 of the Constitution, is really no substantially different from the Section 8C power, other than that under 172, perhaps the separation of powers consideration might loom larger than in the other context. But it's really exercising a similar power.
And the exceptional circumstances here would be that it would make no difference that it is the court that directs the Speaker to allow the motion of no confidence to be decided by a secret ballot than if it is referred back to her, because she's still going to reach the same conclusion.
That's the one. The second one is in the context of the secret ballot here under Section 102 relating to the President, there is not really any other rational way when one gives proper construction to the constitutional provisions for the Speaker to come back and say it will be by open ballot. So I accept it is a situation where, as the Chief Justice raised, are we really talking about a true discretion, or is it a very narrow discretion where there's only really one outcome? We would submit this. This is a case where the outcome is indicated on the facts, and that is that if there is a discretion, the discretion could only be rationally exercised one way. And that is why it would really make no difference to refer it back. And it would still fall within the proper province of what this court can do. Those are our submissions.
Thank you very much, Mr. Manager. Mr. Unterhalter.
As the court pleases.
We're trying some sign language communication, but it's not quite effective about when to take a break. It's not quite effective. But anyway, yes, Mr. Unterhalter.
As the court pleases. Our submissions will be divided into three parts. We, with some circumspection, venture back into the question of discretion that has much occupied the court in the course of the debate with our learned friends. We secondly wish to make some submissions about the nature of the rights that are at stake in this matter and why they are significant for the purposes of parliamentary oversight. And then lastly, we will make some submissions about a central distinction that we draw between circumstances in which transparency and open debate is at a premium in respect of lawmaking, and contrast that with the kind of decision that is at stake in respect of a decision in relation to a motion of no confidence. Let me begin, if I may then, with the question around discretion. There is a central dilemma concerning interpretation that hangs over this court's deliberations, which is, why is it that Section 102 of the Constitution doesn't specify for a secret ballot in respect of a vote of no confidence, when in respect of the election of the president it does so stipulate, and in respect of elections more generally it also specifically provides for a secret ballot. And so the question of interpretation is, well, does that mean that at least implicitly Parliament meant to nevertheless assert that there was a secret ballot applicable in circumstances of a vote of no confidence, or is there some other constitutional rule that is implicated by the silence or omission that is to be found in Section 102? That links to this question as to whether there is a discretion from an interpretive perspective. And may I give you briefly our submission as far as this is concerned. One way of interpreting Section 102 in the light of the oversight functions that are fundamental to a vote of no confidence and the rights that we say are at stake for members of Parliament, both directly as individuals but also as representatives of the public, is that in most circumstances, a secret ballot is required in order properly to exercise those rights. But there could be circumstances in which that may not be necessary. And let me explain how that could come about. There could be a circumstance in which Parliament, and particularly the whips of the major parties, take a view that all members are free of any party discipline, and they may take an open vote on the subject. And you could therefore formulate a rule of the Assembly that said that, generally speaking, the rule that is applicable to votes of no confidence is that they will be by secret ballot. But there could be circumstances of exception where that will not be necessary, and so the other value of transparency might play a different role. So the question then would be, well, in that circumstance, what the Constitution had in mind by not specifying for a secret ballot in respect of Section 102 was to permit of a rule, the rule-making function that has been much referenced by the court in Section 57, to allow that for a rule that, generally speaking, secret ballots will be required, but the rule could specify the terms upon which that specification for a secret ballot would not be of application. That would explain both then why the Constitution didn't find it necessary to specify a constitutional rule of obligatory secrecy in Section 102, left it to rulemaking, but nevertheless the rulemaking that is consistent with the Constitution would ordinarily require adherence to secret ballots as the mechanism by which the requirements of oversight and the rights at stake are properly redeemed. And just to answer two questions which I think were posed to my learned friend Mr. Budlander and has been asked a number of times by the Chief Justice, if there are two forms of review that this court could undertake, well, perhaps three issues that arise by way of remedy. The first would be to enunciate what exactly is the presumptive position in respect of votes of no confidence. That is, a presumptive constitutional rule applicable, that is applicable is the vote, in respect of votes of no confidence, is that there will be a secret ballot. So that is the first declaratory order that could be made. Of course, it would then be up to Parliament to fashion a rule that is consistent with the constitutional norm that is announced by this court, and the court would not presume that Parliament would not carry out its declaratory order. But should Parliament not do so, then, as happened in Ambrosini, this court could bring under review whether the rule that Parliament adopted in compliance with its constitutional duty as enunciated by this court, that would be a matter that this court could bring under review, as happened in Ambrosini. And finally, if the rule properly formulated allowed for the exception that we suggest might be possible, and that exception was not properly applied by the Speaker in particular circumstances, then we would submit that if the discretion was not properly applied, then that could also be justiciable before this court, as was held in the case of Lakota and another versus the Speaker in the Western Cape High Court. It's 2015 4 SA 133, where the application of the discretion under the rules by the Speaker was brought under review, unsuccessfully as it turned out, but the court didn't suggest that the issue was not justiciable. So our submission and our respectful answer to the interpretive question that this court has been grappling with is to submit that it was not the Constitution didn't specify for an obligatory constitutional rule in respect of votes of no confidence that they should be by way of secret ballot. It left it to the rule, but the rule that would be consistent with the Constitution is a rule that would, in all but the most exceptional circumstances, require that there was a secret ballot. That is our first submission in respect of some of these matters. 5
minutes being up,
yes.
A thought just dawned on me, and it is this. The removal of a president from office, particularly when you need no reasons to do so, such as is the case with Section 102.2, it's a very serious thing. It could easily destabilize the country.
Indeed.
You could actually push the country to something worse than junk status. Why should you hide now if you want to remove him because, for whatever reason, you were expecting this, him to do this for you, he didn't do it, and so on. You don't provide any reason. You just come together and say, let's remove this fellow. We don't like him. Should you not be open now, be seen as a person who's making a dramatic move with far-reaching consequences? Why should you hide? Come out. Let us see you, particularly because you don't even have the reasons.
Yes.
Could it be that the drafters of the Constitution deliberately left secret ballot in relation to the removal precisely because it's something so serious that you really need to be daring enough to do it, considering the possible consequences?
Yes. It's a possible...
And therefore, it is, of the three options, is what require, permitted, or prohibited. Is it not prohibited?
Yes. We submit that that is an unlikely construction of the Constitution, and for two reasons. The first is that in respect of the election of the president, there has been a constitutional specification for a secret ballot. And we, with respect, following some of the questions posed by the Chief Justice, would follow that line of reasoning to say that the removal is potentially much, much more stringent and serious and more broad-ranging in its consequences, because now you have an incumbent who actually exercises power and you are seeking to remove that person. But it's precisely because of the power that the president exercises, both in the constitutional scheme of powers, but also, of course, as the head of the party that governs the country, that it is vital that the actual vote on this crucially important matter should be by way of secret ballot, because the forms of coercion, both subtle, express, and potentially problematic for the purposes of the voting your conscience, as you're required to do, are manifold and obvious. And so it's particularly because of the gravity of the decision, but also because of the width of the decision. We would reference, I was going to come to this proposition, but in essence, the important distinction between impeachment and a vote of no confidence is that the range of reasons that might ultimately motivate the House to vote against an incumbent president can be many and varied, and they can engage with one's conscience at many different points of connection. And it's because there are so many considerations that are relevant to that it should be taken in a sacrosanct way, that is to say, in the privacy of a decision taken quietly and without scrutiny. As my learned friend Mr. Mainechi pointed out, of course the debate about it will be free and open, and transparency will be served, so there will be public deliberation and through Parliament on the point. But when it comes to that moment where an individual who is discharging his or her functions as a matter of conscience has to say, which way am I going?
And of course, members of Parliament are responsible people. That must be the assumption behind whichever way you vote. They are not irresponsible people who are just going to decide on a motion of no confidence without good reason.
No, it's absolutely of the gravest import. But the issue around secret ballots is this: one wants individual MPs to give authentic decisions. That's the key political principle that underpins this constitutional guarantee. And to give an authentic decision, it must be one that is free from coercion. Its authenticity depends upon, in this instance, secrecy, because given the gravity that a government, in effect, well, at least a cabinet will fall, as will the president, with very significant political implications for the country, it is up to each person to do so in the most authentic way that chimes with their conscience. And to do that, one has to create the correct circumstances for the exercise of the right, and that is by way of a secret ballot. So that is why our interpretation is, it is almost always presumptively the case that these rights will be exercised and this function will be exercised by way of a secret ballot, but we do allow for perhaps very special circumstances in which there is such an atmosphere of freedom and openness in the House and such an absence of any party coercion over the matter that there is a sense that the general rule can be relaxed in that very special circumstance.
Help me to understand, when would it be, would the atmosphere conceivably be free of unpleasant consequences, even if you vote openly in support of a motion of no confidence?
Well, a first step, and we don't say the only step, but certainly a first step, is that the whip is withdrawn. So as happens with certain motions before the House, it is simply said, everyone has a free vote in accordance with their conscience. If that is announced by each of the whips, then that begins to create the circumstances in which there is less need for a secret ballot, because part of
You mean the party whip?
Yes.
But what about the other leadership now?
Well, again, I've said that's just the first step. The other steps would have to be to say, we genuinely are concerned about leadership. We want a proper expression of whether the House has confidence. There will be no consequences for anybody.
Is that realistic?
Well, it may not be. It may be an unusual circumstance and perhaps unlikely in the context of the practical application of political power, but we at least allow the possibility, and perhaps it's a purely idealized and idealistic notion of how politics can operate in the Assembly, but we at least allow that the framers of our Constitution had an optimistic view about human nature and politics and said it could happen. It probably won't and never will, but at least we allow the possibility that it might.
Should the possibilities we postulate not be in keeping with reality?
Well, we don't say that
just to explain myself, is it possible that you can have members, I beg your pardon, of any political party, whether ruling or opposition, just voting anyhow?
Well,
in relation to a motion of no confidence, particularly in their own leader?
Well, we allow and admit that it's not easy in our present political circumstances to imagine such a political society. But it doesn't mean that the framers of our Constitution didn't conceive of the possibility we could one day evolve into such a position where the idea of conscience was given such primacy in the way that Parliament organized itself that it was willing to create the conditions itself outside of a secret ballot process to allow for authentic choice to be made. We don't say those conditions prevail at the moment, and perhaps they never will, given the reality of political power, but it doesn't mean that the framers of our Constitution entirely excluded that possibility. Constitutions are framed in two sets of circumstances that some of the worst features of human nature are given effect to, and sometimes some of the best. And perhaps the framers of our Constitution at least contemplated both for the purposes of how this particular aspect of our Constitution was going to be framed. That's our first submission, and we submit that deals with the question of discretion. The issue is not, is there a discretion in any simple sense? The question is, what is the right rule that would have to be formulated for the purposes of giving expression to the constitutional principle that we have sought to submit to the court? And then it would be a question of Parliament giving effect to that rule. The rule may involve a discretion, and with respect, we would agree with the Chief Justice that this court will not dictate how a discretion is exercised. But what the rule must look like is a rule that must be consistent with the constitutional principles that this court enunciated, and that's what Parliament would have to do. If I could very briefly...
I'm sorry, Mr. Untitled, I'm sorry.
Yes, Justice Chapter.
As I understand your argument, then the question would be whether at present we have such a rule. And if it is not there, what should happen to the decision of motion of no confidence in an environment where Parliament has failed to make a rule which is consistent with Section 102?
Yes. Well, in that circumstance, the court would declare that the rules that prevail are not consistent with the Constitution and would direct Parliament to exercise its rulemaking powers in such a way as to bring its rules into conformity with what the Constitution required.
At a practical level, what happens to the motion of no confidence?
Well, the motion of no confidence must, in this scheme at any rate, await either the reformulation of the rule or simply an undertaking by the Speaker that she will proceed in accordance with, for this vote of no confidence, in accordance with the principle that this court has enunciated. So if this court were to enunciate the constitutional principle here, that it must be presumptively in secret, then, and the Speaker would then say, well, having seen what the court has to say about this, I will then regulate that this vote will take place in this way, and that, at least for this decision, would answer the problem.
Doesn't that move away from the relief sought by the parties?
Well, under this court's powers of just and equitable relief, it's a question of making sure that the relief flows. I do understand that it all depends how this court ultimately formulates what is the right constitutional principle, and then the relief that is appropriate will flow from that. But we do foresee that it is seen through the perspective of the rulemaking function of Parliament and those rules' compliance with the constitutional principles that the court enunciates.
If we go your route in expressing the presumptive rule, what do we say? Do we say anything about what you consider may be the exception?
No, we would say the court would not have to frame the exception. The court would simply have to say there is a presumptive rule that is applicable for these circumstances, allowing that there could be exceptional circumstances and leaving it to Parliament to determine the scope of that exception. Parliament could choose not to have an exception at all. It could say it's much easier simply to have a rule, but that would be for Parliament to decide.
But if the underlying ratio for our presumptive rule, assuming now on your thing, is X, shouldn't we say that the exception must at least confirm to the underlying purpose of X?
Yes, it would simply be a question of, with respect, being cautious not to dictate to Parliament precisely how the exception is framed. It could be, this court would formulate it at a level of general principle, and it would then be for Parliament to give effect to it through its rulemaking competence. That would be our submission. If I could, in the limited time that I have, just very briefly touch on two further submissions. The first just concerns the proper characterization of the rights. We have sought to emphasize in our submission to the court that the rights of freedom of conscience and political decision-making stand at the forefront of thinking about the responsibilities of MPs and their rights. But we have also wanted to draw the distinction between the fact that these are not simply rights enjoyed by members of Parliament as individuals, but also in their representative capacity. And we have sought to emphasize, in respect of Section 42(3), that the requirement of being a representative is government under the Constitution by the people. And those important words, simple as they are, give expression to the fact that the rights of freedom of conscience of MPs mean that they are not there under diktat of party discipline for all purposes. They are there to exercise certain rights on behalf of the people. And when it comes to a vote of no confidence, as has already been emphasized by numbers of those who've submitted to the court, the vote of no confidence is an essential oversight discipline in respect of executive power. And to have government by the people through its representatives in Parliament means that those representatives have to have freedom of conscience and the conditions to exercise that freedom if it is going to be a meaningful sense of government by the people. That is not something created simply as a function of party discipline, because it will then not be government by the people. And that's how we have sought to construe the rights and their relationship to the representative role that Parliament plays through its MPs. If I could then lastly just touch upon a distinction that we have sought to emphasize, because it seeks to find a path between the values of transparency on the one hand and the importance of authentic decision-making on the other, relating to votes of no confidence. We have drawn a distinction between the lawmaking functions of Parliament, which are policy-driven. We say that there is a link between the party that you have come to Parliament to represent, where the party has a program and has gone to the electorate to seek its mandate for that program. In those circumstances, it is much more explicable and much more sensible to have a regime where there is transparency as to how the people's representatives, through their party, give effect to a political program that has won the adherence of the electorate. But an entirely different state of affairs arises in circumstances where a vote of no confidence is at stake, and that relates to the nature of the decision that is being made. That is not programmatic. You don't go to the people at a general election asking how you will exercise your conscience in relation to a vote of no confidence. That deals with circumstances that arise in respect of whether the executive, and in particular the president, is conducting himself or herself in a fashion that is consistent with the Constitution and is consistent with what is required of that office that wins the confidence of the House. And since that is not programmatic, it's not related to parties and electoral systems, we submit that stands on a different footing. And the rights of freedom of conscience, the rights to take political decisions here, should not be limited in circumstances where there cannot be authentic votes that are cast to exercise this vital set of rights and this vital discipline over executive competence. There, we must create the best conditions for authentic votes being cast, and to do that, as many parties have submitted before you, requires that there should be a secret ballot, because without that, many forms of both subtle and not so subtle coercion will give rise to inauthentic decision-making, and the oversight functions of Parliament will be diluted to the point that it may mean that the Constitution suffers in this vital part that it plays in overseeing executive competence.
Mr. Untitled, before I forget, this government by the people, is it only an individual member of Parliament who is capable of giving practical expression to the concept, or even a political party itself? Considering that it is the political party that the people voted for.
Yes.
That individual's face was not even on a poster or something.
Yes.
So why the assumption that Section 42(3), to the extent that it refers to a government by the people, it necessarily points to an individual member of Parliament as opposed to the party that he or she belongs to?
We submit it as both. Parties have a duty to try to reflect that constitutional principle, but so do MPs as individuals. And numbers of courts have said that, including this court. In the certification judgment at paragraph 186, the court affirms the fact that it's not just parties that are the engine, as it were, for democratic responsibility and representativity. It is also individual MPs, and much the same thing was said by this court in the UDM case and by the Western Cape High Court in the Max case. So both roles play together, but in this instance, it's because we emphasize freedom of conscience as being so vital to have authentic decision-making in relation to this kind of a decision, which, as this court has said in respect of, in a slightly different context, concerning fitness for office in relation to the office of the NDPP in the DA versus the President's case, the court emphasized that because fitness is a concept that has some aspects of subjective judgment, one has got to have the right conditions under which conscience dictates how one thinks about whether a president still retains your confidence as an MP. And that then will help to ensure both accountability and government by the people in this important respect. Those are our submissions.
Thank you very much, Mr. Untitled. Ms. Bauer.
Chief Justice, members of the court, I agree to take the graveyard shift because there was a perception that we were the lone voice in relation to a number or at least two primary issues. But what it does boil down to is that there seemed to be unanimity that it's a matter of interpretation. The nub of it is whether it is a mandatory framework or whether it's a permissive framework. And our position was at the outset that it's a permissive framework, unlike the position adopted by the UDM and the IFP. And we say that in the given circumstances, in this permissive framework, one is obliged to order. But what is obligatory is that in this permissive framework is that a secret ballot be permitted, because to do otherwise would render effective executive oversight nugatory. And we do maintain that, unlike the view of my predecessor here, is that the starting point is not one of secrecy, but the starting point is one of openness, because that's one of the main founding values of the Constitution. And so when one looks at how one goes about interpreting the permissiveness of Section 102 of the Constitution read with other provisions, one looks at this as a departure from the main principle of openness. And we accept that the motion of no confidence is not an ordinary motion. So in order to address that, I first look at the question of why we say it's not mandatory. It's been stated on quite a few times that there's no express provisions that in absence hereof, one is unable to say that all motions of no confidence should be by secret ballot. So if this court were to find that it's mandatory, then the rules can't be interpreted differently. Then one must say that ultimately the Speaker has no discretion and that effectively it's a foregone conclusion that there must be a secret ballot. And Justice Cameron raised this morning the issue, well, given the important characteristics one looks for in a president, one seeks to have that president appointed by secret ballot, then the converse must also be true when one seeks to remove that president. But numerous other international examples show us that whilst they have adopted the secret ballot approach in respect of the appointment of the president or the election of the president, it doesn't necessarily fall so that when it comes to the removal, that it's automatic that that's also by secret ballot. Germany, America, Austria, there's permissive provisions that allow for it, and in a number of cases, a number of MPs have to vote that it's by secret ballot, or a percentage of MPs have got to vote that we're going to do it by secret ballot.
But in the end, our constitutional...
Sorry, my brother, the 5 minutes is still running.
I apologize.
And at the end of the day, when one interprets our Constitution in itself, then one has to look as to whether it was the intention of the drafters that the position should be mandatory or permissive. And that takes us to the question which was then raised by Justice Kampepe and Justice Madlanga this morning. Well, what did the drafters intend? When we look at Section 1, Section 19.3, Section 86.3, then when they wanted the secret ballot, they expressly said so. If they wanted the secret ballot to apply in respect of all elections and all removals, then it would have been very easy to say that. But they didn't say that. And ultimately, when one looks at that in the context of Section 57 and 59 of the Constitution, what they did do was they said, well, we will elect it when there's a choice of a president via secret ballot, but what we'll do with Section 57 and 59 is we'll tell those elected members that they get to regulate how Parliament should operate, and we'll tell them in Section 59 that the starting point of such regulation is one of openness. We also say that openness isn't an absolute principle, because we know that it's got to be measured and weighed up against other principles of the Constitution: openness, transparency, accountability, good governance, multi-party democracy. And that is one way in which we interpret these provisions. And so what one then has to say is that what the Constitution in Section 102, Red Rule Schedule 3, does do is it says, well, we don't expressly exclude all secret ballots. We leave it to Parliament to ultimately, we say it's permissive, and how it's going to be done is ultimately to be determined by the rules of Parliament. And that is what the debate between Advocate Budlander and Justice Froneman followed on, as to exactly the ambit of how you go about doing it. And we're inclined to agree with Advocate Budlander in that regard. Now, if one looks at, well, how do you go about determining it? The core principle that one is looking for here is to ensure that Parliament can perform its executive oversight function. An absolute openness which allows for all votes to be open may very well be detrimental in the circumstances now to permit for such executive oversight. And so the framework is laid to say, well, there's a basis upon which to deviate from that openness and to permit a secret ballot. The methodology is to be determined by Parliament in its rules. And correctly, that is a narrow discretion which is allowed by the Constitution. And one must accept that in reaching that conclusion, there is a tension between the founding values. On the one hand, of openness and transparency. On the other hand, you must allow for a publicly defensible decision. One may very well conceive where a motion of no confidence by means of an open vote could in future be permissible, or could in future be where the entire Parliament or members of Parliament decide we intend to have an open vote, to reach a conclusion to saying that all votes of motions of no confidence would be closed. We effectively take that decision away from Parliament, and we must then come to the conclusion that that was what the intention of the drafters of the Constitution was. And we don't find that within the language of the Constitution, because it then goes back to the position, well, why didn't they just say so?
Well, the 5 minutes is up, my brother.
I'll pass for now, Chief Justice. Thank you.
Now, tell me, if you employ a purposive interpretation that takes into account 86, Schedule 3, then you look at 102. What purpose is a secret ballot meant to serve in relation to the election of the president? And what is the logic, or what purpose explains the exclusion, if it is meant to serve any purpose at all?
Well, Chief Justice, if one looks at the election of the president, one understands that you only have the secret ballot with there's more than one candidate. You then have potentially two candidates from the same party or two candidates from two different parties. You are effectively putting a president into power with members of the legislature that is going to serve effectively under that president. There is a logic to be said that whoever comes into power is an influence in the manner in which the legislature operates by whoever voted for or against the president, be it from his own party or otherwise.
No, they are an independent arm of the state. How does the president have influence over them?
Well, at the end of the day, the president appoints his cabinet largely from members of the legislature initially. He's invariably a high-ranking member of the political party who's the majority in Parliament. There are committees within Parliament that the executive has to account for. The legislature has to enforce an executive oversight power or power over the executive. At the end of the day, there is some logic to be said that we allow the members of Parliament to be able to have a say in that president that is to be appointed.
So if you don't vote for the president, you may not become a cabinet minister or deputy minister?
That's not what I'm saying. I'm saying...
Okay, please explain it, because I want to understand the differentiation between voting for and the voting to remove.
You're effectively given a free vote, free from all other kinds of entanglement when you vote for a president in power.
Why?
Well, because of the nature of the person and the position that is being held by the president, that you as an elected member who's taken an oath to serve in Parliament and the Constitution, you afforded that opportunity.
How is that different from removing the same president?
Well, the difference comes in the wording in the Constitution, that whereas you've been given an express right to do that under the Constitution, you're not given that express right under the Constitution to do that. One has to infer from the provision of the Constitution that you're given the power under Section 102 to bring a notice, a motion of no confidence, but the methodology by which you do so must be interpreted in a purposive manner, taking into account all the provisions of the Constitution. It doesn't stand to reason that because you do one by secret ballot, you must do the other by secret ballot. There's a number of examples in our Constitution of appointments which appointment methodology is more stringent than the removal methodology, or different methodologies adopted.
I don't understand. I thought you would give me the reason, the objective reason for wanting to afford members of the National Assembly the opportunity to vote a president into office by way of secret ballot, so that we would be able to understand why it ought not to necessarily follow that in the case of a removal, it has to be by secret ballot as well. In other words, I was expecting you to give me reason. So you see, when you vote the president into power, these are considerations that explain why a secret ballot is the route to go. And now, when it comes to removal, those considerations can't apply because of X, Y, Z.
Well, there may be different considerations which apply when it comes to a removal. Considerations which doesn't emerge from the text of the Constitution, but would emerge from Parliament. And hence, one would leave the position on how that is to be regulated to Parliament. And for that reason, we take the view that what the Constitution does is it says it doesn't close the door to there being a secret ballot, but it leaves the door open to saying that it's permissive to have a secret ballot. And the discretion constitutionally would be a narrow discretion because it would have to comply with the constitutional precepts. And hence me saying I'm in agreement with the submissions by Advocate Badlander that it's that it's such a narrow outcome in this instance that there's only one conclusion. Or the wording used in the Trencon decision that there's one foregone conclusion that you'd be guided by the law and the Constitution in this instance.
Ms. Bauer, I do understand your submission that there seemed to be a tension between these provisions together with the provisions of the Constitution. But in the context of interpreting Section 102 purposively, as Mazibuko guides us, shouldn't we understand the provision in the light significantly with Section 42? Because he tells us that we have to focus on Section 42, particularly in relation to the oversight and the scrutiny of the actions of the executive.
Justice Nkabinda, if one has regard to Section 42, then one accepts that there is a parliamentary obligation to have that executive oversight, and that executive oversight is regulated by Section 102 in respect of motions of no confidence. It doesn't necessarily follow to do your job as Parliament and to, in every instance, exercise that executive oversight. It has to be in a secret ballot. We unhesitatingly say that in the facts before this court, or in the scenario before this court, that it certainly does warrant a secret ballot. All we're saying is that in order to reach an interpretive paradigm in this case, one doesn't have to reach the conclusion that it has to be so in each and every instance. And that's why we addressed the issue as to whether the relief sought is in fact broader than what is required, by asking that an interpretation of the provisions or a declarator that in every instance where there's a motion of no confidence, one has to find that it has to be done by secret ballot. It doesn't necessarily follow that every exercise of executive oversight would always be meaningless or always be predetermined if there's an open ballot system. that comes. In the current situation we have is that we do have a majority party, and we have a scenario in where the submissions have been made that executive oversight would be ineffectual and illusory in the circumstances.
I beg your pardon. In the circumstances, a declarator sought by the applicant in 3.1, would you support it?
Yes. Give me a moment.
May I just read it to you for convenience? It is declared that the Constitution requires that motions of no confidence in terms of Section 102 of the Constitution must be decided by secret ballot.
We support 3.2, Your Lordship, Ladyship.
3.2 is the alternative.
It's the alternative. That what the provisions of the Constitution does, it permits motions of no confidence in terms of Section 102, that it's a permissive provision and not a mandatory provision.
Ms. Barber, can I just understand the basis for your argument? You accept that in the debate with the Chief Justice, you accept that the constitutional considerations and the constitutional structure and the individual issues that arise are similar in election and removal, but you find the omission significant.
I find the omission significant.
And your argument, therefore, is trying to accommodate the omission, but accommodate it very narrowly, a bit like Mr. Untitled did, by saying it's possible but very rare. Am I understanding you correctly?
Indeed, Your Lordship.
And if one could therefore understand the omission differently, it might affect your argument. Well, let me put to you what's on my mind, because it arises from Justice Jafta's point this morning, which is that Schedule 3 deals with the investiture of Parliament, the constitutive arrangements to elect the Speaker, to elect the Deputy Speaker, the President, and the Chair and Deputy Chair, and also in provincial legislatures. Therefore, you have to have a schedule that sets it out, like a footnote to the Constitution. And if one therefore sees that the specification of the election in Schedule 3 is an extended footnote, it even brings in the Chief Justice, who's got to set out rules and specify who's going to chair the session. If you look at the end of the schedule, it's very detailed, because it's the constitutive process which is the initiation of the lawmaking power in the country. Whereas with removal, you don't have to have all those details. I understand the argument can cut both ways. I'm not sure that it was put to Mr. Mpofu or to Mr. Mukaitobi on this basis. But if one understood the schedule as specifying a whole host of detailed provisions which aren't necessary when you're reading the Constitution as a whole, one might come to a different conclusion from you if one based oneself purely on the considerations that Mr. Budlander, Mr. Mpofu, and Mr. Mukaitobi and other counsel mentioned.
Justice Cameron, I considered it at the time Justice Jafta raised it, and what bothered me about it was Schedule 3 isn't limited to only the first election. And if it was intended to put a mechanism in place where after Parliament would effectively then regulate it, then the wording of Schedule 3 would have said for the first election. But Schedule 3 applies subsequently thereto as well. So my difficulty with accepting the proposition put to me is, how does one then explain its ongoing application? Because that wouldn't go with the language of the section in Schedule 3. And if one accepts that the schedule is part of the Constitution, and only in the instance where there's a conflict between the schedule and the text, would the text prevail. I mean, this court decided that very early on with the Executive Western Cape decisions. Then one must accept that when the legislature devised this process in the Schedule 6, it was aware and knew what it was doing in Section 102, and one would have to read those two together.
Well, that brings me to your submissions, which use the concept of intention, which this court has for many years issued. I think at the time that you and Mr. Bishop were intimately concerned with the court doesn't mention drafting intention because extracting meaning from legislation or a document or especially from the Constitution is a process of looking purposively and contextually at words used in context rather than looking at intentions.
But one has to look at the Constitution itself as drafted. One may not want to look at what the drafters intended or look at the preparatory documents, none of which is before this court, to which, if I recall, one could have regard to if this court so wished, or if any of the litigants had sought to put it before the court. But if one looks at the actual language of what the drafters put there, then there is a distinction to be drawn between an election and a removal. And it's an obvious distinction to be drawn because they could very easily have put in secret ballot and that would have been the end of the matter. And if they put on par an election and a removal, then one would have said, well, they're equally important and they would have been treated equally. It probably goes back, and in preparing for this, we looked at what has happened internationally and with some of the other parliaments, and especially the Italian context, in where secret ballot has actually been detrimental to deliberative democracy within that parliament, and where in removals they actually then went for the open ballot in a number of instances where motions or no confidence motions was put before the House precisely because it undermined democracy. Now, I'm not suggesting that that's in any way competitive here. I'm simply saying is that are we being short-sighted in closing the door to an instance in where openness might dictate that an open ballot would be required for a motion of no confidence before Parliament at any stage? And do we really in this instance have to make that call now, when we have sufficient before this court to actually say, well, all we actually need is the risk or the threat or the possibility where we will not be able to have proper executive oversight in instances with an open ballot, and that warrants permitting that the Constitution allows for that permissive provision and to give the Speaker guidance without interfering with any separation of powers by effectively saying that is actually the only foregone conclusion you can reach within the law. And to do that. And one of the reasons, and the Chief Justice touched on this, there is a difference with Section 102 with the removal of the President. 102 doesn't only see the removal of the President, it sees the end of his cabinet. All other members of cabinet and deputy ministers must resign. That's very different from Section 89, where you remove the President by a resolution of 2/3 of the House. There doesn't come a requirement that it's a removal of an entire cabinet. And there are issues of stability that may very well be important to Parliament at the time. And there may very well be instances that you would want to leave those decisions to Parliament to be taken. Those are our submissions.
Thank you very much, Ms. Bauer. Mr. Semenya.
Chief Justice, my learned colleague indicates that he has to go first as the justice for.
In fact, he's right. Mr. Moerani, I apologize to you.
Apology accepted.
Mr. Moerani, it has since become necessary to take a 10 minutes break.
Yes, I've already taken mine.
Well, you're watching live visuals out of the Constitutional Court, where the legal arguments on whether secret ballot be allowed or not allowed during a vote of no confidence in President Jacob Zuma is underway. Proceedings have been adjourned for a short 10-minute break. Now, some of the brightest legal minds in the country going head-to-head in the highest court of the land today. And this could prove once more to be a seminal day in the history of our country. Chief Justice Mogoeng, as usual, captivating us with his usual intellect and wit. Let's see what happened in court this afternoon. Well, after lunch, we've heard from a few organizations that have applied successfully to be friends of the court. We just saw Advocate Nazreen Barner there appearing for the Unemployed People's Movement, bringing up maybe the tail end of proceedings for now. Earlier, we had Advocate David Unterholter appearing for the Shosho Kiza Progressive Movement. He made his submission focusing on discretion and the nature of rights at stake, that the significance to the parliamentary oversight functions. Now, he did focus on rights to freedom of conscience of MPs and rights to take political decisions, and he did emphasize the conditions to exercise those freedoms be created. Now, he also submitted that MPs are needed to make authentic decisions in line with their conscience, and this can be done through way of secret ballot. Well, we also had Advocate Hamilton Manicha appearing for the Institute of Security Studies, also a friend of the court, saying in his submission that a secret ballot is necessary to ensure that parliamentary oversight function is indeed fulfilled, that is to hold and keep the executive to account in the form of the president in this case. Also Advocate Jeff Budlender appearing for the Council for the Advancement of the South African Constitution, focused on judicial overreach, separation of powers and accountability in parliamentary processes. Well, of course, the Chief Justice certainly not going easy on legal representatives today, questioning whether the Speaker is under a constitutional obligation to have this vote done in secret. Budlender having to work very hard to convince the Chief Justice of his submissions, and that the Speaker should exercise the discretion lawfully in just one way, because discretion does mean that one has a choice. Well, it's been more than half a day of tedious but very necessary submissions. We'll take you back to those proceedings once they do resume in the Constitutional Court. But for now, let's move on to some other news.